In this episode of Retiring Today, we're talking about law changes in Washington and your retirement.
And we'll talk to estate planning expert Charlie Bottenberg about how the Secure Act may impact your planning.
Join us for Retiring Today. Welcome to Retiring Today. In this episode, we're covering the Secure Act, legislation recently passed in Washington and how it affects your retirement. I'm here with Loren Merkel. He's a certified financial planner. And Loren, you sit down with families every day and you talk about what's going on with their retirement. And when it comes to the Secure Act, you're having a lot of conversations about it because it's one of the biggest most significant changes to retirement planning that you've seen in decades.
This is brand new legislation. This was just passed December of 2019, and you're right, Molly, we're already having an abundance of conversations about it because it is such a significant piece of legislation. This country, every once in a while, goes through, well, first of all, there's legislative changes that take place all the time. But every once in a while, we have a massive piece of legislation that really changes the landscape of retirement planning, and this is one of those pieces of legislation. And now this industry has to do a quantum leap as far as the strategies that we use to catch up with this legislation. This legislation was first introduced and passed in the House as of May of 2019. But there were many iterations of what this legislation, like most legislation, it takes some time and there's changes and negotiations that take place. And then finally, December 20th, it was passed. And now we have the final verdict, pretty much. There will be still some alterations that take place with the legislation. But for the most part, we know how it's going to impact them. And now this industry really needs to come up with some strategies to make sure that our retirement dollars still do the best for us, like we always had the plans in place for before.
And just to set this up, the Secure Act is an acronym. It stands for Setting Every Community Up for Retirement Enhancement. And Loren, it's kind of been passed as a bill that will help small businesses get more access to 401k plans for employees, something that might change your RMD age. But you're finding that as you look at it closer, because you've been watching this really closely, you and your team, it's not necessarily as great as it sounds.
Yeah, we've been watching it for a while, and of course every great piece of legislation has to have a good acronym and a name around it, and it sounds really good. Setting Every Community Up for Retirement Enhancement Act sounds fantastic.
Enhancement's good.
But when you really unwrap and unravel this bill, it really comes off a little bit differently, so I've renamed it. I've given a different name behind the acronym, which is Seize Every Cent Under Retirement Act. Because this is what Uncle Sam is really trying to do. There's $29 trillion in retirement assets in this country. There's 10,000 people retiring every single day. This country is embarking on probably what is going to be the world's largest transition of retirement assets that we have ever seen. Because 10,000 people retiring every single day, within the next 15, 20, 30 years, those retirement assets are going to be handed down from the retirees to their beneficiaries, their kids and their grandkids. So what the major piece of this legislation that impacts that transition, that wealth transfer, is now these beneficiaries underneath the IRAs and the 401k plans, they have to take all of this money out within a 10-year period of time, as opposed to stretching it out over the course of their lifetime. So the serious implication there is now Uncle Sam is going to get this revenue. So most of that $29 trillion in retirement accounts has never been taxed. Uncle Sam has never taxed that money. When you take that out, or your beneficiaries take it out, now he gets to tax it. And if your beneficiaries could have to have it out within a 10-year period of time, as opposed to stretching it out over maybe 20, 30 plus years, the level of tax that Uncle Sam can apply to that money now probably is going to be much greater, which means that we are going to get to keep less of our savings. Uncle Sam's going to get more.
And so you're talking about one of the nuances of the Secure Act. This thing has a lot of elements to it. We just did a show where we went in depth with the team here at Merkel Retirement Planning about the Secure Act. So if you want to see that whole show, it's on our YouTube channel. It's Merkel Retirement Planning is the YouTube channel. But Loren, today we're going to focus on the legacy piece, because for this big transfer of wealth that you talked about, this elimination of what they called the stretch provision or the stretch IRA, can change how people are writing their retirement plans.
For the last decade or so, we've been really focusing on creating stretch IRAs, or also called multi-generational IRAs, which really does give beneficiaries the most amount of power of how they use these assets, and really being able to decrease the level of taxation that they have to pay on the inheritance. And that's what this law really changes. Let's just give them a quick example, because we'll show you an example of how we set up these IRAs prior to the law, and then we'll show you how this law really impacts that type of planning. Because really for the last decade or so, this is how we've structured them, but now it's completely flipped on its head, and we have to redo the estate plans for many people that we put in place for the last decade. So the example of the stretch IRA, how it used to work. We have Mr. Smith. He has a $525,000 IRA. Now, over the course of his lifetime, he will be mandated to take out a required minimum distribution from 70.5 till the day he passes. So over that time frame, he has to take out about $325,000 when he passes. Based on the distributions and the assumed growth of 6% per year, his account value will be $838,000 that he's going to pass on to Mrs. Smith. Mrs. Smith also has to take required minimum distributions after 70.5, and so she's going to have to take out about $161,000. And when she passes, she can pass on to their 4 kids $925,000. The kids are going to take distributions, and the sum total of all those required distributions are going to total about $4.5 million. So what this family did by incorporating the multi-generational IRA is they turned a $525,000 IRA into a $4.5 million family legacy. And the level of tax that is applied to that $4.5 million is significantly less than what would be applied to those distributions now that the Secure Act has passed. So let's go to the Secure Act.
This is the old rules.
This is the old.
Okay, now what does it look like?
This is how it worked in the good old days. The good old days of 2019.
Way back when.
Way back when. The way it works today is the kids can't stretch those distributions out over the course of their lifetime. So let's take Brandon as an example. He received $370,000. He took distributions out over the next 30 to 40 years until he passed.
With the old rules,
The old
right.
rules. The new rules, instead of stretching it out over, let's say, 30 years, he has to have that whole $370,000 out plus growth within a 10-year period of time.
From when his mom passes, right?
From when Mrs.
Because the mom
Smith
doesn't
passes.
have to, because it's non-spousal beneficiaries.
Until she's
correct?
70.5.
Okay.
So this is, and that's a good point, because these RMDs on the first example are only what they're mandated to take out. And Mrs. Smith, because she was spousal. It's
She was
a spousal
married to
IRA.
Mr. Smith.
She didn't have to take distributions until 70.5. So those were only 70.5 distributions.
Okay.
Okay. So with this example, and the thing is that Brandon, when he receives this money, he's probably in his peak wage earning years. He's 50, 55 years old. He receives the $370,000. He's making more money than he's ever made, which means his tax bracket is higher than it's ever been before. And now he has to take this extra distribution, which could push him into another tax bracket, meaning that he loses more of the inheritance.
And so this sets it up really good, Loren, because what has to happen now for a lot of people that are going to be in this situation is getting creative with estate planning. So Loren and an expert on estate planning are joining us next to talk about some of the nuances of this Secure Act and how to get creative when retiring today continues.
Because of the Secure Act, everything about retirement planning has changed. With the stretch provision eliminated, your beneficiaries could be subject to pay higher taxes on the legacy you leave behind. Attend an upcoming retirement planning class to learn how these changes could impact your finances, your beneficiaries, and your retirement. Go to merkelclass.com to sign up today and learn how the Secure Act may affect you.
You've worked a lifetime to prepare for retirement, but getting organized can be overwhelming. Important decisions need to be made about Social Security, health care, and retirement income. Where do you begin? At our Journey to Retirement class, you'll learn how to maximize your Social Security benefits, choose your best health care options, and avoid losses during the next market correction. Spots for this class are limited. Call today or sign up online at merkelclass.com.
Welcome back to Retiring Today. We've been talking about a brand new piece of legislation that is really changing the legacy planning landscape. So what we've done is we brought Charlie Bottenberg with us. Thanks for being with us, Charlie.
Thanks for having me.
And you've been working with the state plans for a number of years now.
That is correct.
And we're so happy to have you here. This piece of legislation is really going to shift the legacy plans of many people. And because it's brand new, there's still a lot of rumors going on out there about what the ramifications are really going to be. So I guess first of all, let's start with what's your message to the families that you work with right now as it relates to the Secure Act and their legacy plans?
Absolutely. So the first message I have for people is, a lot of the families I work with have trusts, and it's really important to have your trust reviewed in 2019. Obviously, as an attorney, we always say you should have your trust reviewed, and I always mean that. But this year, it's especially important. Specifically as it pertains to anybody who's leaving behind an IRA and was counting on a conduit provision in their trust handling RMDs from that IRA down to their beneficiaries. As you're undoubtedly aware, the Secure Act took away our ability to plan with a full stretch IRA, and all of those funds have to be depleted generally within the first 10 years. The problem with what we call a conduit provision is the idea is a required minimum distribution, an RMD, would go from that IRA into the trust and then out to the beneficiaries. The issue is most of the way that they've been written, all that you're pulling out is that required minimum distribution, and that's all the power the trustee has to do. So instead of being able to space out those tax consequences over 10 years, what could happen is somebody could end up with all that gain coming out, all that tax consequence in year 10, and generally speaking, my clients don't want to incur all that tax liability in 1 year, prefer to spread it out over the whole decade.
This is one of the biggest issues with this bill that I've seen, because for the last decade or so, we've been working with our families to develop this legacy plan that does involve this conduit trust, where the beneficiaries can stretch out the RMDs over the course of their lifetime. But just like with the trust that I set up for my daughter's 7, and the way that the trust is established is if I were to pass now, she can only take out what is required from the IRAs and the 401k plans.
Yep.
Which means that the principal and all the growth has to stay underneath the trust. She's only taking out what's mandatory. The problem with this new bill is that my trust says she can't take anything else out. And with the new bill, there's not an RMD until the 10th year, of which she won't be able to take anything out till the 10th year. Whatever money has built up underneath those pre-tax accounts is now going to come to her in one tax year.
Right.
Which could have significant implications as far as how much she actually gets to keep versus how much Uncle Sam gets.
Absolutely.
And so now what are you telling your clients who might have those types of trust in place right now?
It's time to look at it. And as an example, I'm in the process of redoing my own. And we like to joke around the office that when the attorney is taking the time to redo their own, that's usually a pretty good sign that maybe they should be looking at their own too.
It's time to look at it.
But yeah, sometimes you can change language so that they're authorized to take out more than just the RMD. So the trustee with proper tax planning, with proper financial planner support, can look at the total tax picture and say, when is the right time to pull these funds out? But without some significant change in powers to a lot of the conduit provisions that I've been reading, they're not going to have that option. And just like you said, it's all going to come out at the end, and it's going to hit them like a fist to the gut, and nobody really wants to deal with that.
So most of these people that are going to have to make changes to their trust, do you think most of those changes are just going to be a simple amendment of the trust and the trust language? Or do you think for many people it might be let's just scrap the whole trust and start brand new?
I would say for most people it's just going to be an amendment. It's going to be relatively non-invasive. That said, I run into a lot of trusts that are 10, 12, 15, 35 years old. We like to play a little game around the office called Is Your Trust Older Than Your New Attorney?
You guys have a lot of fun at your office, don't you?
I try to. I mean, it's estate planning. You got to keep it a little, you got to keep it loose.
Keep it light.
Because it's tough enough as is. But no, I think for the most part, as long as their trust still meets their basic goals, whether that's providing for grandchildren, providing for kids, providing for a special needs beneficiary, charity, whatever that looks like, as long as the general overarching trust still meets their goals, it should just be a simple amendment. Change some of that conduit language. Maybe it's a revisiting. For instance, if you drafted the trust and at the time you had teenage children, now they're in their mid-20s, maybe it's a situation where leaving the kids as direct beneficiaries on the IRA makes more sense than it did back then, because your average 25, 26-year-old is a lot more equipped to handle finances, as you're well aware, than a 15 or a 16-year-old. So I mean, there should be some review process to not use a car mechanic as an example, but while you're under the hood, you might as well look at the whole engine, right? You might as well take a look at it. Most estate planning attorneys are going to do some sort of a free review and give you an idea of what you should be looking at anyway. So generally speaking, this is a really good moment in time for people to pull their documents out of the safe, knock the dust off, take a look at it, check, does it still meet the goals? If you have an IRA in your portfolio, or you will because you have a 401k or a 403b and you'll be rolling it over at some point in time, check, make sure those rules are set up correctly, and then reevaluate what you want for your beneficiaries, because it could be that when you set this up a while ago, your needs or your goals have changed. Yeah,
most definitely. And with most legislation, there's exceptions to the rule. So far what we've been talking about as far as this 10-year rule is for non-spousal beneficiaries. And there's some even exceptions for those who are non-spousal. So if you're a spouse who receives an inherited account from your spouse, right? So let's say Mr. Smith. Mr. Smith passes away, Mrs. Smith receives the money. She can still stretch it out over the course of her lifetime, or she can consume it as her own IRA. So what this 10-year rule is intended for is what happens when Mrs. Smith passes away and gives it to or sends it to her 50-year-old son. Now her 50-year-old son has 10 years in which he has to have that account liquidated. Now there are some other exceptions as well. And one of those other exceptions is, what if Mrs. Smith doesn't send it to her son? What if Mrs. Smith sends it to her brother, who is 2 years younger than her? Then her brother, let's call him John, John can still stretch the distributions out over the course of his lifetime. So that has not changed in that scenario. The rule is if it's a non-spousal beneficiary, and the non-spousal beneficiary is within 10 years of age of the original account owner, then that individual can stretch it out over the course of their lifetime. So of course there are some exceptions to it, which again is just one more reason, because there is so much complexity to it, so many moving parts, why you should probably consult your estate planning attorney at this point to make sure that the plans that you have set in place still represent your wishes, and if they don't, now's a great time to make some changes.
Absolutely. It's very fact intensive, so you have to be able to sit down and kind of look at the whole picture and get all your fiduciaries involved and make sure it's going to function the way you want it to.
With this legislation, there are some good things about it.
Absolutely.
There are some good, I mean, after all, why would they have such a great acronym as what they do without some benefits of the legislation? So one of the benefits, and this is one they've touted from the very beginning, is that RMD age, the required minimum distribution, has been pushed back to age 72. So the way it was set up before is once you obtain the age of 70 and a half, you have to start taking required distributions from the accounts. Now you can wait all the way up until 72, except for
if you're already 70 and a half. If you turned 70 and a half before 2019, like my dad, like my dad did, you are under the old rule as far as that's concerned, not the new rule.
Yeah, that's right. And this is one of the, so I've called this the RMD trap, because I think that there's a lot of talk, there's a lot of conversation about the Secure Act, but a lot of people have just been casually paying attention to this act and maybe missed some of the minutia that's involved in the legislation, because after all, this legislation is pretty massive. So this trap is let's say you turned 70 and a half in 2019. You were not grandfathered in to the 72 pushback rule, which means you were still required to take a distribution, in that case, by April 1st of 2020. And most people who turned 70 and a half in 2019 would want to take that distribution in the year of 2019, so they're taxed on it in that year, and then they would also have to take another one in 2020. Right. So let's put some numbers around this.
Sure.
Let's say in 2019, the distribution was $10,000. Okay. Let's just make it easy, say the distribution in 2020 was also $10,000, but they heard that they didn't have to take it until 72, but they didn't understand they weren't grandfathered in. There's a 50% penalty, right, Charlie?
That's correct.
50% penalty because they missed the distribution, not only for 19, but also 20. That's $10,000 in penalties, plus they still have to take the $20,000 distribution out. This is one of my fears that is going to happen to many people. Absolutely. Because this rule is so massive.
Absolutely. And if you look at most of the press that the Secure Act has gotten, it focuses on the fact that it's pushed back to 72 and maybe you can't take the full stretch anymore. It's only 10 years. So the fact that there are exceptions in both of the cases, at least most of the major news sources that I've seen, most of the literature that I've seen, it requires an actual deep dive in, it requires an expert to take a look at it. So not to beat the dead horse, but definitely important that this year of all years is the year to get in, meet with your financial advisor, meet with your attorney, probably meet with your tax accountant, make sure everything is still synced up the way it was, because just because it was good 2 years ago doesn't mean it's going to be good today.
Yeah, and the legacy planning, as the audience knows, we're always talking about the 5 components of the retirement plan. We have the income plan piece, the tax planning piece, we have the long-term care, health care planning piece, the investment planning piece, and then the legacy planning piece.
Right.
There's so many moving parts when it comes to retirement planning. I would encourage you to get together with your retirement planner and your estate planning attorney all in the same room to work through these components, because what you do from a legacy planning standpoint certainly could impact what you're doing with some of those other components of the plan. So how do you also encourage people to get together
100%.
in the same room?
The attorney's job is to look at the legacy planning portion of that, look at the compliance portion of that, make sure that your plan pushes funds in the correct direction. The financial planner's job, as you're aware, is to make sure there are funds to do that, but you're also looking at it from a tax standpoint, you're looking at it from a depletion of assets standpoint. We have 2 very different perspectives. Now they may be aligned, they may be working in the same direction, but that's not always the case. And if you don't have your CPA, if you don't have your financial planner, if you don't have your attorney all in the same room, or at the very least emailing each other for advice and help, you're only getting 1, maybe 2 sides of that 3-piece triangle, and it's really important that you have all 3.
Yeah, I want to talk about one last provision as it relates, or this is more of a solution or a strategy that's probably going to become more prominent because of the Secure Act, and that's the disclaiming provision.
Sure.
So let's go back to Mr. and Mrs. Smith.
Okay.
So Mr. Smith leaves his IRA to Mrs. Smith, $525,000.
Yep.
Well, historically or statistically speaking, women will outlive men by about 2.5 years on average. So Mrs. Smith doesn't think she needs the full $525,000 IRA based on her spending requirements and the other resources that she has.
Sure.
So she does not have to take the full $525,000. She can disclaim all of it or a piece of it down to her kids and grandkids if they're contingent beneficiaries, which means that let's say she only needs $200,000 of it. She can take the $200,000, disclaim the rest of it, and then that 10-year clock starts on what the kids and grandkids received then. Maybe Mrs. Smith lives another 5 years, maybe another 10 years, but then whatever she has left goes again, and that's a whole new 10-year window that starts.
Absolutely.
So this is one of the strategies I'm sure you'll probably be working with your families on as well.
Yep.
Which that may or may not include the work of a trust.
Absolutely.
There's a lot of times beneficiaries will not include trust work. But again, just another reason to talk with your planner, talk with your estate planning attorney, make sure everything is done the way you want it to be done. Charlie, thank you so much for joining us.
Absolutely. Thanks for having me.
It's a pleasure to have you. I hope you'll come back.
Love to.
Stay with us. We'll be right back. More about the Secure Act.
Finally enjoying your retirement, but there are so many things to consider. How long will your income last? What will you do about long-term care? How do you set up your legacy to last for generations? Now is the perfect time to attend our Boost Your Retirement class. This class will help you take your retirement plan to the next level and set you up for success. Spots for this class are limited. Call today or sign up online at merkelclass.com.
You've worked a lifetime to prepare for retirement, but getting organized can be overwhelming. Important decisions need to be made about Social Security, health care, and retirement income. Where do you begin? At our Journey to Retirement class, you'll learn how to maximize your Social Security benefits, choose your best health care options, and avoid losses during the next market correction. Spots for this class are limited. Call today or sign up online at merkelclass.com.
Welcome back to Retiring Today. I'm here with Loren Merkel. He's a certified financial planner. And Loren, I was watching you and Charlie talk, and you talked a lot about trusts. And my thought, and maybe some people that are watching, is that trusts are just for the wealthy and maybe the richest.
You're thinking about the trust fund babies.
And maybe that's what the perception is. But you find that lots of different types of situations where a trust is important.
Yeah, there's a lot of different situations where a trust might be necessary or wanted. Let's go back to Mr. and Mrs. Smith. Mr. Smith passed away, Mrs. Smith has the money, and John is their son. maybe Mrs. Smith is concerned that if Mrs. Smith passes away, all the money goes to John. Maybe John passes away and now the money can get outside the family line. Maybe John gets divorced and she's fearful of that money getting outside the family line. So a lot of people will incorporate trust within their beneficiary designations, just protect their money, make sure it stays within the family line due to death, disability, or divorce. And the trusts today, they don't have to cost all that much. I mean, certainly there's some more advanced trusts that cost a lot of money, but in the state of Iowa, most trusts you can probably get done for $1,500, $2,500, somewhere in that ballpark, depending upon the complexities and what you're trying to do with the trust.
Okay, and this legislation, like a lot of legislation, has a lot of layers to it. And I think too, if you're watching and it's kind of hard to follow sometimes the terminology, conduit, some of those other things. The good news is if you have maybe the right people on your team, they're following this legislation for you. So you can be asking your retirement planner about this. Ask them if they know what's happening with the Secure Act and ask them how it will affect your retirement. And if they don't, maybe they're not a retirement planner. Maybe they're more of an accumulation advisor. And then that's a decision that you have to make if they're the right person to help you plan your retirement. So another way to help you kind of plan your retirement is to educate yourself about all the things that go into it, because we just talked about legacy planning today, mostly. That's one part of it. But Loren, the education classes that Merkle Retirement Planning holds, that's a great place to learn about all of the pieces of retirement planning.
There's 5 main components to the retirement planning method that we've created. The income piece, the legacy piece, of course, we talked about today, the long-term care, healthcare planning piece, the investment planning piece. We talk about all 5 of the components at the Journey to Retirement class. This class is specifically intended for those who are within 5 to 10 years of retiring. We talk about all kinds of Social Security maximization, optimization strategies. We talk about tax planning, tax mitigation. We talk about developing an income plan. All these different things that when you're approaching retirement, you really start to hone in on the questions that you might want to have answers to. What happens when you become Medicare age? What do you do with the supplemental plans? All that kind of stuff. And then we also have the Boost Your Retirement class, which is intended for those who are already retired. So if you're already retired, maybe you've already taken your Social Security benefits, then in the Boost Your Retirement class, we're going to talk about the things that you can do to maximize what you've already accomplished to that point and how to more solidify your retirement plan for the next 20 to 25 years.
And those classes are held throughout the metro at various times throughout the month, and they're free and open to the public who sign up. Here's how you can learn more information. It's merkleplan.com. That information is on your screen, and you can sign up for a class if you're interested, or you could always catch another episode of this show. It's Retiring Today, and we thank you for watching.
You've worked a lifetime to prepare for retirement, but getting organized can be overwhelming. Important decisions need to be made about Social Security, health care, and retirement income. Where do you begin? At our Journey to Retirement class, you'll learn how to maximize your Social Security benefits, choose your best health care options, and avoid losses during the next market correction. Spots for this class are limited. Call today or sign up online at merkleclass.com.
From our family to yours, we hope you have a wonderful weekend.
We hope you enjoyed the show.
We'll see you next week.